This is the November 15th, 2022 meeting of the Town of Easton Zoning Board of Appeals. The first public hearing is on for 6:35, so we're going to take care of a little business first. We have approval of minutes from the October 18th, 2022 hearing. Does somebody want to make a motion on approving those?
Before we do,
Yes.
at the first paragraph, it said that Ryan Cook was present,
Okay,
and then it said that he wasn't. And I know that, Ryan, you weren't there. I just
I
think
see that,
I think that needs to be corrected.
as noted. Yes, will do.
I'd like to defer these minutes until after this meeting.
Are there
Actually-
issues with the minutes themselves?
My lack of diligence didn't scrutinize them enough, to be honest with you.
Okay. We'll table it till after the hearing. I'm not sure we're gonna get to it tonight then, but
Yeah, okay.
we'll see. I mean, I don't know if we can have time to read and dissect them between now and,
I guess the only thing is I want to make sure the i's are dotted and the t's are
Mhm.
crossed in case petitioners decide to appeal us.
okay. All right, so we'll table that till after the hearing. We have a meeting schedule that was distributed to everybody. Does anybody have any issue with approving that?
I do.
Right now, they're all scheduled for remote, but obviously it says meeting location and dates are subject to change. Personally, I would be in favor of going to in-person meetings somewhere in the first 3 to 4 months of the year.
That was going to be my complaint, is I didn't understand why everything was Zoom. You know, we're appointed public officials and the people have the right to face us face to face.
That I would say to keep it Zoom until the April meeting, at least through the winter. I still wear masks out, but I'll defer to everybody else, but that's my thought, at least. The January, February, March meetings, Zoom, and then after that, go live.
Okay. Suzanne, can we approve the meeting dates and Zoom for the first 3 months and then
Sure.
decide
But
at our next
why?
meeting?
I still, I want a better explanation than Steve wears a mask. That's not enough for me.
Well,
It
what they're
shouldn't be enough
saying
for the
is
townspeople
experts
either.
are saying, winter's winter and there's more spread of stuff.
You're free to wear a mask at town hall.
Yep, I do. When I come in, I wear it. Ryan and I have a difference of opinion. So we'll have a vote, whatever the vote is,
We don't have to decide on this tonight.
Can we just decide on the dates themselves?
Yeah, I mean, does anybody have any objection to any of the dates that were specified?
No.
Nope.
Okay.
I don't have an objection. I mean, I think I'm available on all those dates. It's sometimes subject to change, but.
Sure.
Mr. Chair, when we publish the legal notices, you need a time, a date, and a place.
Correct.
So I do need a location.
Well, we don't have any legal notices yet for January, correct?
We do not, but it'll be coming. So it has to be addressed eventually.
So I
A month
know,
prior.
I know the rooms become an issue, the availability of rooms become an issue as it may relate to the dates. So For our purposes tonight, to get through January, I'd like to propose that we keep January as a Zoom meeting on January 17th. And in December, we can discuss dates and room availability thereafter.
Is the room not available January 17th?
Suzanne, what's the status on the room availability?
I could get Tuesday rooms, someplace in town hall, either at the Colleen Corona room or location. Tuesdays work better than Mondays, more choices.
Okay.
I see no reason to continue doing Zoom.
Well,
I'll
you know what,
defer to everybody else.
I'll make this simple, Mike. I will make a motion on what you said, that we Zoom January, February, and March. Someone seconds it, we can vote, and that'll be it. Ryan and I, you know, a difference of opinion, I haven't heard from anyone else, but let's do it that way. So I made a
guess we'll do
motion.
January, February, and March every single year, Zoom.
Well, talking about 2023.
The logic holds regardless. But there's a motion, so we should vote on it.
Well, someone's got to second it.
I'll second it.
Okay, motion made by Mr. Merlin to go remote meeting from Zoom for January, February, March on the dates that we have. Seconded by Mr. McCall. All those in favor? Steve?
Yes.
Tim?
Yes.
John?
Yes,
Ryan?
No.
Okay, and I'll vote in favor of it as well. So in December, we will circle back on the rest of the calendar. How's that, Suzanne?
That's good.
Okay. All right. So 6:35, continued public hearing, administrative appeal number 22-10. Applicant is seeking an appeal from denial of enforcement by building inspector for property located at 6 Chickadee Lane. Members of the board sitting on this hearing from last hearing are Stephen Merlin, John Curran, Timothy McCall, Jeremy Kay, and myself. Mr. Secretary, do you want to read the additional memo we received from the planning board and any other comments that may have been included?
Do you want to let the people in first?
I'm working on that while he does
Oh.
this. They can all hear him.
Okay, the only comment was regard to a meeting on November 7th, 2022. The Planning and Zoning Board discussed the administrative appeal for 6 Chickadee Lane. Based on the review of the matter, the Planning and Zoning Board does not feel it is in position to advise on the propriety of the zoning enforcement officer's decision on this matter. The only other items are the letters from Burns and Levinson firm and the firm of McGregor, Laguerre, and Stevens, all loaded up on Permitize,
Yes.
and that's
Yeah,
that's all that's there.
Okay, great. So. Let me get Attorney Flynn in here, hang on. There we go. All right, so just a couple of preliminary statements before we get started on this. First of all, thank you all for coming. I appreciate all the additional information that has been provided. I think for our purposes tonight, we heard a lot of testimony at the last hearing. Everybody should have a presumption that the board members have read all of the supplemental materials, and to the extent any of the board members have any questions regarding what they have, what they've read, or what they don't understand. The board members are going to have an opportunity to ask those questions. The sort of the plan going forward is to give each of the attorneys an opportunity to give just a very brief summary of what was additionally submitted, 5 minutes or so. I'll then turn it over to questions from the board members. And then when that is done, I will open it up to the public, but I am going to ask that we do not rehash the testimony that was presented at the last hearing. I know it's difficult to try and get everybody in, but to the extent we start hearing the same thing over and over again, I am going to stop the additional questions or comments from the public. One other minor, or not minor, but one other comment I have. I know there was some vandalism to the Wolf's property. It's a very unfortunate situation and incident, but it is irrelevant to the proceedings this evening. And as such, I'm going to ask the parties refrain from referencing it, discussing it, accusing anybody of anything, and we will go from there. So I don't know if any of the attorneys would like to initially speak. None of you are on video right now.
Mr. Chair, excuse me, I don't think the attorney for the applicant has been promoted. Maybe he raised his hand.
What's that?
I don't think that you have two attorneys from the same firm.
Yeah, well, Attorney Durning was just on my screen.
Right. But the attorney for the applicant, I don't think has been promoted.
It's Mike O'Neill.
Right, and he's not on the list, but
He's not here.
he's not there, but possibly, I don't see his name. The applicant would know. Maybe you could ask the other attorney to raise their hand. Let's see anyone hands raised.
Well, Attorney Durning is not on the list any longer either.
Mr. Chairman, I am present. I think my video's up.
Oh, there you are. Okay. Well, I don't know where Attorney O'Neill is. But why don't, Mr. Durning, why don't you go ahead and start if you'd like. Like I said, if you could just kind of give us a brief overview of what was additionally submitted, and we'll go from there.
I'd be happy to do that, Mr. Chairman.
Okay.
Am I able to share my screen?
Yes, you may.
Thank you. Is that showing the full length now?
What was that? I'm sorry?
It was cut on my screen, but I think it's showing the full view now, so it's okay.
Okay.
So thank you, Mr. Spillane, for the opportunity to address the board on this matter. Again, my name is Peter Durning. I'm an attorney at Burns and Levinson, and I represent the landowners at 6 Chickadee Lane, Gregory and Barbie Wolf, as well as their daughter Ashley, who's intimately involved in the farming activity on the property. And I think that from the last meeting, the two most pressing issues that the board was debating or reviewing at the close of that hearing was the extent of the application of the holding from the appeals court matter in Clancy, and also a question of the extent to which the building inspector had been asked to review this matter with respect to the special permits. So I'm going to focus on those issues primarily, and then potentially a few additional comments. In the comment letter we sent to you on October 28th, we highlighted the Clancy case. We distinguished it, particularly with some additional cases that have been heard after Clancy. And I think what we drove home in the hearing, and that I think is clear upon review, is that Clancy is good law, but it applies in certain circumstances. And what we had set out for the board at the last hearing and in our supplemental filing is that when you apply the analysis from Clancy about when a property would not get the benefit of being found to be primarily in agriculture, the Wolf property meets that criteria. We had provided a sketch plan that we showed, I apologize briefly at the last meeting, but in that October 28th submission, we gave it to the full board. And in the comments that you received from the petitioners, there was no critique or criticism or question, but I think it reinforces the breadth of the Wolf property that is in use as agriculture, particularly the back acreage of the property, over half of the property. And this was not rebutted by the other side. And so coming to the analysis on Clancy that the board was concerned with, I think this sketch plan and our comment letter gives the board a very good reassurance that indeed this property can be considered as having a dual principal use of both residential and agriculture. In addition, there was an active discussion among the board members about the extent to which the original request for zoning enforcement to the building inspector concerned the special permits, and indeed that material was subsequently provided and added to permit eyes, and indeed the gravamen of the request for enforcement to the building inspector was almost entirely focused on the special permit concerns. Indeed, the element that was added into the petition to the Zoning Board of Appeals regarding a farm as an accessory use was actually not even present in the materials presented to the building inspector. Following up on this, Mr. Chairman, we had provided a very recent comment letter that I think drives highlighting two particular cases, the FOD LLC versus White case and the Tracer Lane case. Both of these, I think, provide a very clear instruction to the zoning board about how it should analyze this request for enforcement, and that it should comfortably come to the conclusion that it can support the building inspector's denial of enforcement in this matter. And in particular, what is important here, the petitioner's response, to the extent they tried to challenge the positions that we put forward last time, was to say that the Dover Amendment does not apply here, and that we are somehow obfuscating by directing the board members to the Dover Amendment. But I think that the FOD LLC versus White case and the Tracer Lane case help demonstrate how indeed the Dover Amendment is vital to your understanding and your analysis of this situation. In particular, in the FOD case, excerpt from our letter, which I have up on the screen, what's important is, I know there seemed to be some discomfort or some discussion last time about the application of Dover or the right to farm bylaw that is present in Easton. But the FOD case gives you a very strong place to land, talking about the length of time that the Dover Amendment has been here in the Commonwealth, and that, as the FOD case talks about, parties who are dealing with land where a agricultural or a school or other protected Dover Amendment use is there as of right, since 1975, they should have the reasonable expectation that those uses are going to be permissible and that those uses cannot be tied to a special permit, which is effectively what the petitioners are asking the zoning board to do here by claiming that these special permits would somehow bar the practice of agriculture as a use on the Wolf property. Similarly, if we go to the Tracer Lane case, this is critical for your understanding because the Tracer Lane, a very recent case out of the SJC, talks about how ancillary features of a property, like a driveway, should be analyzed and understood to be consistent with the primary uses that are permissible on the main parcel. Therefore, to the extent there was any hesitation about whether or not the agricultural use, which is found to be existent and a principal use on the main parcel, could that also then extend Dover Amendment protections to how that use is manifested on the common driveway? And the Tracer Lane case gives you ample material to rule and understand that the zoning enforcement officer, the Easton building inspector, was correct in the denial of enforcement in this matter because the Dover Amendment and its protections apply to this property and to the driveway as well. Mr. Chairman, I think that's the bulk of the materials that I wanted to get to you with respect to amplifying what happened before. I did want to share some images to give you an understanding of the pastoral setting that the wolves have on their property. That is really ample space for the sheep and goat population that they have there. It's really quite a lovely setting. But I also want to note that there was an element of the comment letter that you received from the petitioners that talked about the change that occurred when the residents of Chickadee Lane had applied to the planning board for a change in the diameter of the turning circle. And the petitioners highlight this as somehow an admission that when there is a change, that the special permit, the common driveway special permit, necessitates a change. However, I think as we noted in our comment letter, the circumstance is distinct. Again, in that case, you're talking about a change in a dimension of the plan itself, where the dimensions of the turning circle that is located at 2 Chickadee Lane was desired to be changed. And that is something that was directly governed by the terms of the special permit itself, whereas the as of right use for the practice of agriculture is not something that was germane or would need to be changed. If you are familiar with the history of how this was changed, it is interesting insofar as there's a lot of commentary in the respondents' notes about applying the strict terms of the common driveway special permit and the maintenance agreement to the wolves. And yet what we have in the instance of the changing of the turning circle was something being advocated by the other neighbors to change the special permit. And there was not a desire to have the full breadth of the turning circle that the planning board had initially approved. And indeed, this driveway is designed by the special permit to be 18 feet in length, and it's currently only 11 feet in length, which could be contributing to some of the congestion issues that are present there. I think that's the bulk of what I wanted to share with the board today. I will be available if there are other questions, but I think based on the materials that we've submitted in writing and what we've provided to the board today, I think it's a very reasonable conclusion for the board to reach that they should uphold the building inspector's determination. And I thank you for the opportunity to be heard this evening.
Thank you, Attorney Durning, appreciate that. Attorney O'Neill,
Thank you. Thank you. Thank you, Mr. Chairman.
you're welcome.
Good evening, Mr. Chairman and members of the board. Mike O'Neill with the petitioners. The special permit for the common driveway is for the purpose of serving 3 residential lots. Kyla, can you put up the application for the special permit, please? Kyla, is it peer professionals?
What is that?
Kyla, are you recognized?
She's not on the panel. What's her?
She's at professional, peer professionals.
Okay.
There she is.
Okay, she's on the panel now.
Okay. Kyla, can you please put up the application for the special permit? All right, this is the application for the special permit. Proposed use residential. Now can you, this was submitted by Attorney Marsan, the attorney for the applicants for the special permit. Can you please go to the next page of this, Kyla? Okay, now this is from Attorney Marsan's submission to the board for the special permit. This is his memorandum. He's listing the regulations that must be met in order to get the special permit. Finally, the board must find that the requested use will not impair the integrity or character of the district or adjoining zones. Here, the requested use is a common driveway to serve 3 residential dwellings. And these are consistent with the use that prevails in the district where the land lies. Can you, the next page, please, Kyla? Attorney Marsan listed the other requirements that are applicable. Bylaw provides, it shall be unlawful for any owner or person to change the use or increase the use without going back to the board for a new case over which the board shall have complete administrative power to deny, approve, or modify, which is precisely what should have been done in this case. Now, can we go to the special permit itself? Here is a special permit. Okay, now let's go to the findings. Okay, stop here. Next page, please. Okay, next page. Okay, all right. Finding number 2, use requested, that is residential use, is listed in the table of use regulations as a special permit. Next finding, the requested use is desirable. The requested use is residential use. Next finding, the requested use, residential use, will not create undue traffic congestion or unduly impair pedestrian safety. Here, the common driveway simply diverts residential traffic from one lot to another. Next finding, the requested use, that is residential use, will not overload the public water or drainage system. Now let's go to the next page here. Number 7, the requested use, residential use, will not impair the integrity or character of the district or adjoining zones. And then it goes on to describe the conditions that are imposed upon the granting of the special permit. Namely, a maintenance agreement approved by town council recorded at the registry of deeds. Now, let's go to the maintenance agreement. Here's the maintenance agreement. And let's go to let's stop here. We're at the second whereas clause. Okay. Whereas the owners are developing lots 21, 22A of the property. Said common driveway will provide access to and allow for the use of 3 residential lots within the property. You go to the next page, please. Okay, up above. Okay, Now, here we see that the maintenance agreement provides rights, reciprocal rights from of the party of the properties again of the owners of the property as to each other. The respective owners, they can enforce the property, the requirements of this maintenance agreement against each other. That is, this is a restrictive covenant. It's a contract among the parties in addition to being part of the special permit. Now I'll go down a little bit further. Okay, stop. Okay, condition 3A. The driveway shall be used only for the common enjoyment and use of the owners of the 3 residential lots to be developed on the property. Now let's go to subparagraph P. P. I'm looking for P. P here. Okay, stop. The driveway shall not be used in a manner which is inconsistent with the residential character of the property. And no noxious, dangerous, unduly noisy, or offensive use shall be made on of any part of the driveway. Nothing shall be done thereon which will result in the disturbance of the tranquility of the property, or which is or which will become an annoyance or nuisance to any or all owners of lots within the entire subdivision. It is abundantly clear, beyond dispute, number one, this special permit was issued to provide access to 3 residential lots. Number two, the Wolves admit that they are operating a commercial farm. The Wolves admit they have changed the use. Therefore, they have to come back to the board for permission to change the use. They're in violation of the special permit. Absolutely clearly. We request that the board find the Wolves in violation of the special permit. Now, I'd just like to say a couple of words in response to Mr. Durning's comments about the Dover Amendment and the 2 cases he cited. The FODC case is about easements. It's about interpretation of easements. There's nothing to do with anything like this. It does not. We have a case in which we have a special permit that's in existence already. We have a contract, and the Dover Amendment says nothing about invalidating existing special permits or existing contracts. As a matter of fact, hello? Oh, wait a minute, I'm on the Zoom. Yeah. Okay. The Tracer Lane case says that in that case, the restriction that was imposed by the town of Waltham was not reasonable in the circumstances of that case. It does not amount to a blanket trump card. It doesn't say that there is no restriction that can be imposed. Absolutely, in this case, not only is it reasonable to impose this condition, this is what they agreed to. Everybody agreed to this from the get-go. It is unreasonable to assume, it's illegal to assume that all of that should be thrown aside because they want to change the rules. The Dover Amendment has nothing to do with this case. This case, the cases that they cite have nothing to do with this case. Again, the Dover Amendment is not a blanket trump card against all regulation. The Dover Amendment, if it applies at all, which it does not, says that regulations must be reasonable. This is a reasonable regulation that is already in existence, and we would respectfully ask the board to find that the Wolves are in violation of the special permit for a common driveway. Thank you.
Thank you, Attorney O'Neill. I'm going to turn it over to the board for questions. However, I have one question first. Um, Attorney O'Neill, since have brought it up, hypothetically speaking, what if the board makes a determination that although the maintenance agreement may have been violated, it may not be a zoning matter per se, and decides to disregard the terms of the maintenance agreement? How do we then still find, in your opinion, that the building inspector was incorrect in determining that no zoning violation has occurred?
Because this is a special permit, you've got to be bound by the special permit. Special permit was issued to allow for a common driveway. So if they violate the maintenance agreement, they violate the special permit. So when you have a
I
violation,
understand what you're saying. I'm asking if there's a way for the board to find that a zoning violation still occurred if, as has been argued, that the maintenance agreement is outside the purview of this board in determining whether or not a violation has occurred.
the
And that
maintenance
it's a
agreement,
private agreement between the parties that very well may have been violated by the Wolves. I don't know, but it's been argued that we should not be considering it specifically.
the special,
Can we still find that there was a zoning violation if
Yes,
that's where the board falls?
yes, you can, Mr. Chairman, and you must, because the special permit is expressly conditioned upon the maintenance agreement. So if there is a violation of the maintenance agreement, there is a violation of the special permit. And if there is a violation of the special permit, that certainly is within your purview.
Okay, thank you. Steve?
Yeah, I'll take a first crack at some questions here. So addressed to Mr. O'Neill, Ms. Bennett. Now, normally we don't accept submissions from parties when they're represented by counsel, but Ms. Bennett submissions were accepted. So on November 1st submission, it's clear, as Attorney O'Neill has said, that the petitioners are saying that the claim is on the two special permits only, nothing to do with right to farm or Dover. So does that mean that the petitioners are saying that farming is a permissible use on that land right now? So that's the first question that I have.
No, we are not, because the special permit forbids it. The special permit restricts this land to residential use. It's
Okay.
It's-
So despite that, you're saying that we shouldn't consider the farming, right?
Well, the right to farm law, as Mr. Hand has testified to you, was never intended to apply in situations like this. It was intended to apply to existing farms and to protect existing farms. This is an abuse of the right to farm law, and it's a horrible precedent. Just think of all the established neighborhoods and residences that if you allow this to happen, would be horrified to think that all of a sudden a farm could be propped up next to them out of the blue.
Okay, so Mr. Durning, Attorney Durning put in FOD, which mentions that it's foreseeable in the future that if a use is allowed, that it could come in the future. So let's say I live in a residential neighborhood, and let's change it from farming to a religious institution. So am I to assume that if I buy a nice house in a nice neighborhood, that 10 years from now, it might turn into a religious institution, a church or a synagogue or something? Is that what FOD says? That you're supposed to have the foresight to assume that? And if that's the case, isn't a foresight to assume the farming's legal?
Yes.
And by the way, when I'm asking questions, don't assume I'm leaning one way or the other. I'm
Okay.
trying to get a
Okay.
handle on what's going on.
Okay, in this case, we have extremely strong facts against that argument. Number one, the Wolves themselves enforced the restriction against the Bennetts and against the Clotier Gagliardis. They told Portier Gagliardi's that they would not sell to them if they were going to have farm animals. They said they wouldn't live next to a farm. And they also imposed the requirement to Kyla Bennett that she could not have any commercial use in her property. So, so they should not be heard to say that none of this applies to them. And then we have almost 20 years since then of residential use in an established residential neighborhood. Now all of a sudden, they say that their daughter they want to start a farm for their daughter to help her get into a veterinary school. Well, it's certainly not foreseeable that there would be a farm in these circumstances, particularly where the Wolves themselves disavowed it, where the Wolves themselves insisted that there be no commercial use of any kind.
So where in writing is that the Wolf said that, and is that binding on us even if the Wolves did say it? Isn't that like a contract more than a year in the future, whatever that is?
Well,
you're going to go back to law school, statute of frauds, a contract to be performed more than 1 year later must be in writing. So did the Wolves ever put anything in writing?
Okay, sure. That
and
is,
should we be bound by that if they did?
Sure, sure. Those are good questions. It is in verified complaint that we filed, is in the materials that we filed with you. You know, we've put forth in writing in what we've submitted to you, and we've included it in our verified complaint. And the simple fact is that it is not foreseeable. Under no circumstances can one say that it is foreseeable that after 15 years of living in a residential community like this, that use would be so drastically changed.
Isn't that what FOD says, though? You have to assume that it could happen? The piece that Mr. Durning, Attorney Durning, showed us says that you have to assume that it's possible.
FOD.
So whether it's 15 years or whatever.
FOD said there were no restrictions. FOD was simply an implied easement where they were operating on a blank slate, and the circumstances were that they implied an easement, and there was nothing to indicate how that land was going to be used. It's far different from this case when there was everything to indicate how the land was going to be used. It was indicated by how it was used and by their own representations as to how and demands as to how it was going to be used. So apples and oranges between FOD in this case.
Okay, so you heard at the beginning of the meeting that the planning board had no comment for the zoning board. So the protocol in this town is that whenever issues come up for the zoning board, they ask the planning board for a comment. So these are the planning board special permits, which were given at the time. The fact that the planning board has no comments on an alleged violation of their own permits, what does that mean to you, if anything?
What it means to me is that I respectfully disagree with that, because it is a special permit. It is a special permit that provides rights that the plaintiffs relied upon. They relied upon in buying their houses and building their houses and in paying taxes, and they are entitled to have it enforced. Now, and the special permit specified what was to happen if there is to be a change of use. Now, Mr. Durning and his clients can come in to a hearing to determine all the facts and circumstances with notice to all the parties and all the neighbors to see what their position is with respect to whether it's a good idea or a bad idea. So, in other words, this should not be foisted upon people in circumstances such as this. If they want to change the use, then do it in a fair fashion, respecting everybody's rights and respecting everybody's right to be heard, not least the requirements of the special permit.
Are you saying the use is that for the driveway or the use for the Gagliardi's lot? So there's two different uses here. One is the common driveway, and then one is the Gagliardi. I'm sorry, the Wolf's lot.
What
So,
I'm-
is that two separate changes or one change?
The change that I'm talking about that needs to be addressed by a board is the change from residential use to commercial farm use. That's the change that has occurred.
Okay, but you just told us at the beginning that we shouldn't consider that it has nothing to do with that. So now you're coming full circle and telling us we have to go back to that.
I'm
So
sorry.
this is where I'm getting, I don't want to say confused, but I'm trying to understand your argument, because I went through it at the beginning. And Ms. Bennett's papers of November 1, what you just said before was very clear. This is about the maintenance agreement, has nothing to do with Dover, has nothing to do with right to farm, and now you just are sticking that in there, that we have to consider that. So which is it?
I'm saying that right to farm has absolutely nothing to do with this, and the Dover Amendment has nothing to do with this. What I'm saying is that it has to do with the special permit that was issued and whether or not they are able to change the use that is allowed under the special permit.
Okay, so let me ask you this. We went through presentation, I think it was yours, on the special permit, that it was subject to review by town council. So it was actually a private agreement, and the town council was just supposed to review it, presumably to say that it wasn't in violation of Easton bylaws of some kind. Would you agree with that?
No, I would not, respectfully. It is a condition. It is a condition of the special permit, and it is provided. It is an essential condition of the special permit. As a matter of fact,
Okay.
if you
The town council didn't write the agreement, right?
the special permit says that the town council shall review it.
View it, but the
And that's-
town council did not write the maintenance agreement,
No,
right?
We could give you Mr. Marsan's entire.
Yeah, but Mr. Marsan's, I do this all the time, even in court. I cut people off, so. But Mr. Marsan's brief is Mr. Marsan's brief. It has nothing to do with the actual permit itself. It was his thought process that was presented to the planning board at that time, right? So the fact that Dave Marsan, who I knew very well for years and years and years, put something in his brief doesn't mean anything to me unless it's carried into the permit
Which it is.
itself. So
Which
my
it is.
question is, yes or no, did the town council write the maintenance agreement? Yes or no? Not whether he reviewed it or not. Did he write it?
I'm not privy to whether or not he wrote
Okay.
it. I am.
Did the planning board dictate the terms of the maintenance agreement? Yes or no? Or did it just accept what was presented as a, to them as an agreement by the parties?
The planning board had presented to it a maintenance agreement, and I would add that there already was a maintenance agreement preceding this particular go-round. There was a previous maintenance agreement similarly in effect, and it was required that there be a maintenance agreement in order to comply with the bylaw, and that was the case. It could not have happened. It could not have legally gone through if there was no maintenance agreement. It was an absolute condition of the special permit.
So let me ask you the same question I asked last week. And Chairman Spillane hit upon it in his observation question. Isn't this really a dispute on the maintenance agreement contract and not a zoning issue? Isn't that why you went to the Superior Court first to file an action to get relief?
No, respectfully not. I went through all what I did, going through all the different provisions of the maintenance agreement, of the special permit and everything leading up to the special permit to say, this is for the purpose of serving, the common driveway is for the purpose of serving 3 residential lots. That's clear as a bell. And we could, I could have given you more if I went to the background history before this. I could have showed it.
Yeah, but
you
the
showed-
background history before that and the prior maintenance agreement is not before this board, is not subject to this hearing. It's the current one. So
Yeah,
let me ask you a question this way. Does the fact that you filed the suit and the fact that a judge of the Superior Court issued an injunction preclude us from doing anything at all?
No, no, it does not, because there were two separate causes of action. In the lawsuit, we are suing under a private contract, which the maintenance agreement is. It's a private restrictive contract, which has the Dover Amendment has no bearing on, the right to farm has no bearing on. Dover Amendment has nothing to do with, and it is also a provision of the special permit. The special permit is clear. I went through all this stuff to indicate that everything in the special permit says this is to serve 3 residential lots. 3 residential lots. This is what the special permit is, to enable 3 residential lots to be developed. And sure enough, they were developed. And sure enough, and here we are 15 to 20 years later, and all these parties have relied upon this and paid their taxes and built their houses and raised their families. And now there's a change.
Okay, so you're suggesting to us, this is my last comment question because I'm taking up too much time now, that the wolves can never farm on that land because of the maintenance agreement for the driveway. Is that correct?
What I'm saying is that if they want to farm on the land, they would have to go back to the board and ask for permission to change it.
But that's if they, so let me ask you a different question. If there was a different access road to the wolf's land, would they be able to farm there? Hypothetical question. If the wolves had a different access other than this particular one that we're talking about, would they be able to farm there?
No. I first of all, I want to caveat my answer here because I can't answer that. It's difficult to answer that in a vacuum without knowing exactly what this other access is. But I'm going to say my answer is no, they aren't, because they have committed themselves to this common driveway to serve 3 residential lots. That's clear as a bell. That's what they built their house on. That's what they sold property to the Gagliardis. That's based upon the fact that this is residential lot. And so that's a special permit provision. That's what's operative here. And so now, so in order for relief from that, they'd have to petition the board for a change with notice to all the interested parties.
Okay. Just last point here. Does the injunction that's in effect stop them from a zoning violation because they can't use the premises for the except for the safety of the animals? So that's what it is, right?
No,
so in
no,
effect, the court has enforced the order with the injunction. Yes or no?
No, that's not. No, the injunction doesn't go that far. The injunction restrains them from using the common driveway for purposes of the farm, with a few exceptions. It does not deal with the fact that the special permit says that this is for 3 residential uses, 3 residential properties. It doesn't address that part.
But you keep saying that the right to farm and Dover have nothing to do about it, and then you keep circling back to it. See, that's the issue I have. I'm sorry, Mike. I took up way too much time, perhaps, but I'll yield to somebody else.
Okay, thanks, Steve. Ms. Bennett, you do have your hand raised, and before we move on to any other board members, if you'd like to say something briefly, that's fine.
I would. Thank you so much, Mr. Chairman. I would like to first address your question where you said, would this be a violation without the maintenance agreement? And I think it is. I think as Mr. O'Neill showed you in his presentation, the plain language, which is the words that the judge used, the plain language of the permit itself show that the purpose of this common driveway was for residential use only. for 3 residential lots. Mr. Durning keeps saying, no, it's just residential character, but there are a number of places. First of all, I don't know what the difference is between residential use and residential character. I think it's too fine of a point, but the permit itself says in a number of places that it's for residential use only. It is worth reiterating that the Wolves do not own this driveway. This driveway is partially owned by my husband and I. It's partially owned by Deneen Cloutier and Bill Gagliardi. They are operating a large-scale commercial operation on our property without our permission. The special permit that was issued by the Planning and Zoning Board, they made representations to the Planning and Zoning Board that it would be for 3 residential lots. Nowhere did it say that there would be commercial use would be allowed. Nowhere did it say that. It would not be reasonably foreseeable for us to assume that a large-scale commercial farm would come in next door to us using our land because they represented to us and to the Planning and Zoning Board that this was simply for 3 residential lots. So that's the first thing I want to say. The second thing I want to say is that Mr. Durning's 2 cases, again, Tracer Lane is apples and oranges because that was one landowner. That was not somebody sharing a driveway. It was just one landowner and a zoning issue. Totally inappropriate and inapplicable. And the FOD LLC, as Mr. O'Neill said, that case did have an easement with 2 different landowners. However, the judge made a big deal, if you read that case, about the fact that in FOD, it was an implied easement. There was nothing in writing, and there was no restrictive covenant. In our case, we have a granted easement, which is filed with the Registry of Deeds, and a restrictive covenant. So those cases are really not applicable. And then finally, my last point, to answer Mr. Merlin's questions, it all comes down to the driveway. I'm trying to make it as simple as possible. There was a special permit issued by the Zoning Board of Appeals to 3 parties, the Bennetts, the Wolfs, and the Cloutier Gagliardis. We each own a portion of that driveway. The permit says it's for residential use. Residential does not equal commercial. The Wolfs fully concede that they have a commercial operation. It is not safe. Their own affiance said, Mr. Ferenstein said he can't turn his truck around. Well, that's because this driveway was not constructed in a way for large commercial trucks to come down on a regular basis. That's why Mr. Ferenstein can't get down here. The driveway, and I believe Mr. Durning is wrong. I apologize if I misread this, but I thought the permit said 12 feet. And indeed, the narrowest part of the driveway is 12 feet, not 18 feet. This is an inappropriate driveway. It's not safe for a large commercial operation, and the Wolves simply do not own it. There's no way in the world we could have known back in 2005 that they would have opened up a large commercial farm based on the fact that we all thought that that permit that was issued by the Zoning Board of Appeals was for residential purposes. Whether or not the Wolves could farm if they had their own driveway, I don't know. I don't care. It doesn't matter. What matters is that they're bringing commercial traffic and operating a large-scale commercial operation over my land and over the Cloutier Gagliardi's land, and I don't want that. And so for you, if the town of Easton decides that it's okay for a landowner to use someone else's property just because it's farming, I think that's a taking, and I will treat it as such. Thank you.
Thank you. Attorney Durning?
Thank you, Mr. Chairman. There was quite a lot that was offered. I'll try to make my comments brief, but just on the last one, on the taking, there absolutely is no taking. That is a completely specious argument. I think what's important to emphasize here is why we are here. There was a request for zoning enforcement that was denied, and this board is reviewing how the zoning bylaw is applied to this circumstance and if enforcement should have been taken. All of the considerations about the extent to which there's a private dispute over the maintenance agreement are not germane to the zoning context. Now, I will assert to you that a lot of what Mr. O'Neill provided in terms of, even if he says it's in a verified complaint. A lot of those hearsay comments about what representations were made, seems like it's trying to make some type of fraud in the inducement argument. But we're not here on whether or not the contract was inappropriately obtained or not. We're here to discuss the zoning that applies to this property. And agriculture is an as of right use in the residential district. So Mr. Merlin's question of could agriculture take place on this lot? Absolutely, unequivocally, that is permitted under the zoning for this property. To the extent there's a question of the descriptions that have been offered, the petitioners like to say that it's absolutely binding on residential use. Again, I would say that agriculture is permitted in the residential zone. And to the extent there was the passages that Mr. O'Neill was referencing about the requested use was for there to be a common driveway. There wasn't a special permit process to request 3 residential lots. That was also as of right. So I think the dimension is, can there be a common driveway? And what you've heard advocated is that Mr. O'Neill would have preferred or would have directed that the Wolves would have been forced to go back to zoning authorities to pursue an as of right use on this property. And that is squarely where there is a Dover concern, because he wants to mandate that the Wolves' pursuit of an as of right use of agriculture on this property should have been subjected to further zoning review and a special permit. And that is an impermissible constraint under the Dover Amendment for this use. And that's where the focus of this conversation and the debate among the board members should go. We are here in a zoning context, and the private party dispute over interpretation of the maintenance agreement is in Superior Court. But what's before you is, how does the zoning bylaw apply to this circumstance? Thank you.
Can the
Thank you, Attorney
parties
Jordan.
make
Can I-
a private
Steve, hang on
agreement?
a second. Steve, hang on a second.
Yeah.
I think I asked this on the last hearing, but just to follow up since it just came up. It's a by right use, but you did acknowledge at the time that not every residential property in the town of Easton, in all likelihood, could commercially farm on their property should they choose to. And I'm not trying to put words in your mouth, so correct me if I'm wrong, but that's what I heard at the last hearing. So how does this property differentiate from, my next door neighbors or somebody else's next door neighbor
I
or somebody
don't know
else
where
on
you-
this board?
I don't know where you live, Mr. Splenda.
Understood. But
Primarily size, that they have in excess of 5 acres is what's going to get protection under the statutes. So primarily it's a size consideration. Mr.
Okay.
Splenda.
Thanks. Sorry, Steve. I didn't mean to cut you off. So.
Yeah, it's okay. I cut you off. My mind's churning. So for Attorney Durning, if you have a statute such as the Dover statute, Dover Amendment, as they call it, can the parties make a private agreement which is stricter than what the Dover Amendment calls for? And if they can, is the maintenance agreement such a private agreement that's binding on the parties?
Theoretically, I think parties could bind their land through a private agreement or record easements on their land that would be so restrictive. I don't believe the maintenance agreement does that in this case, certainly not. And from the zoning context, that wouldn't change the zoning that's applicable to the properties.
Okay, thanks, Mike.
No problem.
Okay.
Anybody else on the board have any questions?
I have a couple.
John, go ahead. Floor is yours.
Thank you. I'm not sure if this question is best directed to Attorney Durning or Attorney O'Neill, or maybe for both of you. Would you agree that when issuing a special permit for a common driveway, a maintenance agreement is required by the Town of Easton bylaws.
Yes,
Mr. Kern, yes, I would agree that it's required.
Okay. So knowing that it's required by the bylaws, let's go back to the special permit that was issued in this particular case. And maybe this question is best directed to Attorney O'Neill. I want you to pretend that there's no maintenance agreement, okay?
yes.
Within the body of the special permit that was issued here, where does it say that this special permit for the common driveway is being issued for residential lots only?
Okay, so the application for the special permit says use, residential.
Okay,
Yeah.
no, sir.
I'm sorry.
With all due respect, I asked you about the actual special permit itself, not the application. In
Okay.
the body of the special permit,
I'm sorry.
where does it say that it's being issued?
Okay, so that all of the findings that I read to you, 7 separate findings that says the proposed use, which is residential use, is, satisfies the bylaw. It's not going to harm the health. It's not going to cause any traffic. It's not going to cause congestion. It complies with the health and safety of everybody. It's consistent with the neighbor, and all these things that say the proposed use, and the proposed use is residential use, because they said that.
Okay, well, maybe I'm missing something, but I'm looking at that document, and under, you referred to the findings. The findings are, in subparagraph 1, they go from A through J. I don't see the word residential used in that document anywhere.
Okay, if you look at paragraphs 2 through 5 and then 7, it says the use requested. And as I started to say, the application says that the use requested is residential. I'll read it exactly. It says proposed use, residential.
And you're taking that from the application?
Yes. The application says the proposed use is residential.
Okay.
And that's included in Ms. Bennett's submissions of November 1st. And we have a copy of it right now if you wish us to put it up.
No, that's okay. I've looked at it. And just as Mr. Merlin indicated earlier, you shouldn't assume that the questions that I'm asking have any bearing on what I'm thinking about.
Understood.
This.
Understood.
So just to get back to what you just said, you're saying that for example, on subparagraph 2, the use requested is listed in the table of use regulations as a special permit in the district for which the application is made.
Yes.
And you're referring back to the application, which said that the use is for residential.
Yes.
Okay. Now, of course, we do know that there is a maintenance agreement here. What is your position on whether or not the maintenance agreement is incorporated by reference into the special permit that was issued for the common driveway?
Yes, I say it is. It is a condition of the special permit.
Okay, and can you locate something in the special permit that was issued which says that the maintenance agreement is incorporated by reference into the special permit?
The language that they say is that it says that the approval is subject to the following, and then it lists several subparagraphs, and then subparagraph 2 says that the rights granted by the special permit are subject to satisfactory review by town council of the maintenance agreement. And the maintenance agreement shall be recorded at the registry of deeds. And so, you know, that is a condition. So it is a condition of the special permit, that the maintenance agreement is a condition of the special permit.
Okay, so what you're saying is that because the town council was supposed to review the maintenance agreements, by your interpretation, that means that it's incorporated by reference into the special permit.
Well, because of the fact that the permit itself says that it's subject to various conditions, including the condition that that the maintenance agreement that was attached to the application shall be reviewed by the town council and recorded at the registry of deeds. So they ordered that the maintenance agreement be recorded at the registry of deeds to provide that covenant running with the land shall be in place against all the owners of the property to maintain that road and to plow it and whatnot, and whatever else that maintenance agreement provides.
Okay, maybe I'm missing the point here. I was asking whether the provision that says that town council would review the maintenance agreement means that the maintenance agreement is incorporated by reference into the special permit.
Okay, it does not use the term incorporated by reference, but it does say up above, it says that the special permit approval is subject to the following conditions, one of which is this lengthy paragraph about the maintenance agreement, and requiring that there the maintenance agreement be recorded at the registry of deeds. So this was not something optional. They required that the maintenance agreement be recorded at the registry of deeds.
And are you saying then that because the maintenance agreement had to be recorded at the registry of deeds, that per se makes it part of the zoning issue here, and again part of the special permit that was issued by the town?
I think that it has to be taken into context that the entire body of the document says that the special permit approval is conditioned upon various things, including this maintenance agreement. And I thought we heard a few minutes ago that it was agreed that the bylaw required that there be a maintenance agreement. And, you know, we can go down that road if we wanted to establish that fact. But in any event, this is the language that they used. In any event, as I mentioned before, there was a previous maintenance agreement before this one. You know, that would, so it is, you know, I submit that maintenance agreement is a condition of this permit.
Okay. Just give me a second.
No problem.
One of the provisions that you pointed to in the maintenance agreement was subparagraph P, which says that the driveway shall not be used in a manner which is inconsistent with the residential character of the property.
Right.
Was that provision in the prior maintenance agreement that you just referred to?
I don't know the answer to that off the top of my head.
Well, I'll tell you, just based on my review of the document, it was not. I don't know if that has any impact or effect on the deliberations, but okay, I'm not sure I have anything else right now, so perhaps I should yield to somebody else.
Okay, thanks, John. Jeremy, do you have any questions?
I don't have any questions. Thank you for asking.
Okay, no problem. Tim, any questions?
No, I don't have any questions for the attorneys. I just, for when we get a deliberation, I have a couple matters I'd like to discuss with the board, but other than that, I don't have anything.
Okay. There's one hand raised in the public. Mr. Gagliardi? You're on mute, but there you go.
Can you hear me?
Yes, we can.
Great, thank you, Mr. Chair. So this is part two with a lot of arguments from the respective parties, right? And I appreciate everyone's time and attention to this, but I would just like to raise something that I observed last night at the town meeting and how the town itself values restrictive covenants. So last night there was a special town meeting and there was extensive dialogue about the potential disposition of the Center Street School, as I think we know is now sort of past life and is a new school. So I don't know everyone who was there, but certainly the select board, town council, town administrator, the finance committee, and they all strongly, they first initiated and then strongly supported the inclusion of restrictive covenants in the proposed purchase and sale agreement. This is to be marketed, but the proposed purchase and sale. And they did it to protect the town's interest. And they did it for three reasons. The first is that the rights are legally binding. The second is they go with the life of the contract, right? And the third is that if there were to be a subsequent sale, there would be assignable to subsequent parties and be legally bounding. So a motion to include these restrictive covenants was made by the town administrator. It was unanimously approved by all of the governing bodies, and it was approved by a wide margin at last night's meeting. This is all registered voters. So I'm not sure that there could be clearer evidence of the town's governing bodies supporting and acknowledging the enforceability of restrictive covenants agreed to during a real estate contract. I think it's the central issue. And I can see, strained faces about what we should be deciding here or not. But you cannot cast aside this central argument when you have a special permit that you now have restrictive covenants that are clearly a part of. We're going to lengths to say that, and then to say that it's not really part of what you should be considering here. This is clearly in the town's interest. It is a condition upon which we spent a large sum of money to buy this land, and these two things go together like glue.
Thank you very much. Appreciate it. Another hand raised for Sarah. Welcome.
Yep, thank you. Sarah, welcome, 116 Randall. So a couple of points on this. There's a lot of talk saying this doesn't have to do with right to farm, but it does. The town just passed by 2/3 majority right to farm. And although Mr. Hands came and said his intent was to protect existing farms, that's not what people in town voted on. They voted because they wanted the right to farm on their property. And the other piece of this is, they keep referring this to as a commercial farm. By definition, all farms are commercial. You have to make a certain amount of money to qualify as a farm in the state. When you say commercial farm, people are thinking of 16-wheelers coming in and out of there a million times a day. That's not what we're talking about. They're carting away their manure to be good neighbors. It's not like there's tons of truck traffic, and that their feed store brought a little bit too big of a truck. That's not the issue. But I think this does go directly to right to farm. That passed very easily, 2/3 majority in town. And, their covenant does not talk about that specifically. So I don't think the zoning board has the right to tell them that they can or cannot. This seems to be a neighborly dispute. And I think the question is, how far do you have to go beyond abiding by the law to appease your neighbors? And I think the answer is none. That's it. Thank you.
Thank you. Ms. Bennett?
Thank you. Just two very quick points. First of all, one of the members, I'm sorry, I can't remember who it was, asked about the change of use. When we're asking the Zoning Board of Appeals to require the Wolves to come back for a change of use, it's not for a change of use of their land, it's for a change of use of the driveway. The driveway has gone from residential to commercial, it is no longer safe. So we want them to come back for a change of use from residential to commercial for the driveway, not the land. The second point and last point I want to make is that indeed in the special permit itself, it says in page 3, number 4, it says the requested use will not create undue traffic congestion or unduly repair pedestrian safety. Here, the common driveway simply diverts residential traffic from one lot to another, thus having no congestion impact whatsoever. That language is in the permit itself, not in the proposals that the Wolves made, not in the representations that they made that we all relied on, but in the permit itself, it's talking about residential traffic. My issue is there is now commercial traffic, hundreds of cars and trucks, commercial traffic on my land. This has nothing to do with right to farm, nothing to do with Dover Amendment. It's a special permit that was issued by the town for a common driveway for residential purposes that's no longer residential. Thank you.
Thank you. All right, any additional members of the board have any questions, feel that they need any additional information, or we've heard a lot of testimony about the same thing. I feel like we're getting to the point where we're discussing the same thing over and over again. Not that I have any problem with testimony that we've gotten so far, but I'm not sure it's going to be productive to hear any additional information at this point, unless any of the members of the board have any specific questions or concerns that they have.
I do not.
Tim, go ahead.
I just have one question for town council. What is the opinion on when a town votes a new use permit, like right to farm after, this time period? What do you think should trump should one trump the other, or should we go back to the original restrictions?
The question is,
well, these properties were broken up in around 2006. They were sold. And then I'm looking at the bylaws. The town enacted right to farm in 2012. So, I mean.
Well, I mean, the right to farm, I think people attach a lot more importance to right to farm bylaws than they really have in real world as far as the effect. It's mostly ceremonial, but it's protection of existing farms, but I think it's also trying to create or incentivize people to start using their properties as farms to, create more open space.
Yeah, I mean, the second paragraph says, chapter encourages the pursuit of agriculture, promotes agricultural-based economic opportunity, and protects farmlands with the town of Easton by allowing agricultural uses and related activities to function with minimal conflict with the abutters and town agencies. This chapter shall apply to all lands within the town of Easton. So it's kind of pretty encompassing in my opinion, but I just didn't know what your thoughts on that were. And relating to this case, I mean, this is pretty unique. We have restrictions on a permit, but then again, we have this, so.
I mean, I don't think really, I don't think the right to farm bylaw is really an issue here. But I mean, I think a lot of it is, it's almost a ceremonial act. Almost every town in our area down here, because I don't live far from has enacted some sort of a right to farm bylaw. They're trying to encourage people to start using their property to maybe stave off some residential development. And it acknowledges that there are certain nuisances that are attached to farming, noise, smell, dust, stuff, and things like that.
Okay, that's all I got.
Steve, anything?
No. If there's no one else, though, is a motion to close the hearing getting to be in order?
We did allow, Ms. Wolf to speak briefly, as we allowed the applicants to speak as well.
Thank you for the opportunity to speak. Thank you, board. I would like to say that the characterization of the farm as a large commercial farm is very mischaracterized. As you saw from the photos, the farm is not a huge commercial operation. We have very few cars or anything going in and out because most of our sales are online at farmers markets or at fairs, which is where we sell our goat milk soap and our wool. And we certainly do not have hundreds of anything coming up and down the driveway. And I would like to just correct the mischaracterization that that we told the Gagliardis that they could never farm or we did not want to live next to a farm. This is because I grew up on a farm in South Africa and I had a wonderful childhood on a farm. So I would like to say that we always envisioned when we bought the 15 acres and subdivided, and then we're left with 9 acres, that there was always the possibility that we could go back to my childhood and give my children what I had and start a small farm. And the USDA characterizes small farms as farms that earn under $100,000. We certainly do not earn anywhere near that, but we qualify for all the definitions of protection under Dover. We are over 5 acres. We are farming 4.9 acres, and we fit all those definitions. So thank you for your time.
Thank you, Ms. Wolf. Okay, so I don't have anything else that I want to ask. John, you have a question?
Yeah, I guess this question, just one question I would address to Attorney Kennefick. To what extent do you, or what would your opinion be in terms of whether we're bound by any factual findings by the Superior Court relative to this particular dispute?
I took the preliminary injunction, and maybe there was something more detailed than what I saw, but it was only about 2 or 3 sentences. It was on the court form you get. I didn't see a memorandum of decision, but I don't think we were bound by anything on a decision on a PI. It's just a preliminary injunction order. And I didn't see anything in there that said that there was a finding that there was a zoning violation. So.
Right. No, I mean, I don't. The question of the zoning violation was never brought up in the Superior Court, but
no, it
would seem that there was certainly deliberations by the court over what was going on at these properties that led to the issuance of the preliminary injunction.
Mm-hmm.
I guess my question is, to the extent that there is some factual finding that we can glean from that deliberation by the judge in the Superior Court, are we bound by that?
No, I want to see why we were bound by that, but I didn't see any factual findings. It was basically the order just said, and it was Judge Yasayan, who I've plenty of times. He was looking at it through the contractual argument, which I think is probably the proper way to be viewing this, but we can get to that in deliberations. But the only thing I had seen in the order was that he had found that there was a likelihood of success that they would win on a contractual argument. Again, like you said, it has nothing to do with zoning. And based on that fact, he issued the order saying, no commercial related traffic to be using the driveway until, they end up trying the case probably 2-3 years from now. Plus, the PI is on appeal, from what I understand. I looked at the online docket. It looks like they filed some sort of an interlocutory appeal on that.
That's what the docket reflects, but I think there was a statement last time that there was no appeal. I had a question, but it's maybe perhaps better suited for the discussion among the board, so I'm all set.
For what, John? Lost it.
Yeah, I was mumbling, which I do from time to time, forgive me. I thought I had a question, but I think it's better suited for a discussion among the board.
Okay. I don't have any other questions. Attorney Durning, did you want to say something?
Yeah, I actually agree with Mr. Kennefick that the proceedings for a preliminary injunction really aren't germane and there was no findings of fact. But I can just confirm that we had filed a notice of appeal some time ago, and today, after the transcript was prepared, we formally docketed that appeal. So we are appealing the issuance of the preliminary injunction, but more to the point, to the extent there was no real fact finding in that effort. And I don't think it has any bearing on how this board views the applicable zoning. Thank you very much.
Okay, thank you. Attorney O'Neill.
Yes, thank you, Mr. Chairman.
You'll be last.
I'll be last. Okay, so the Superior Court did issue a memorandum of decision which expanded upon its reasoning. So there were, it set forth its findings as to the fact that, including the fact that there was a strong likelihood of success on the merits of the restrictive covenant. So I just wanted to clarify that.
Okay, thank you.
I do see that there's one more hand raised. That if you see that, I don't know.
I think we've heard enough testimony. I don't expect that there's going to be anything new. I understand, but if we keep calling on members of the public, I think everybody's made their presentations at this point.
That's fine. Just making sure you knew.
Yep. Thank you.
Motion to close the hearing, if that's in order now, Mr. Chairman.
It is, as long as somebody wants to make a motion and second it.
Seconded.
Motion to close the hearing made by Mr. Merlin, seconded by Mr. McCall. All those in favor, Stephen?
Yes.
Jeremy?
Yes.
Tim?
Yes.
John?
Yes.
And I'll vote to close as well. Somebody want to start with deliberations or raise any issues or make any points? Tim?
It's my opinion that the maintenance agreement seems like a separate contract, so I'm thinking we shouldn't really rule on that. And then it comes down to the question of if the restriction or the perceived restriction on the permit that the driveway is to be for residential, should that trump a change in use that's brought on by the town at a later time? I don't know if you have any precedent for that, or, I mean, it seems like a restriction. It does say, mentions residential, and, this seems to be in violation, but again, they could, I guess, come back and reapply and try to, I don't know, mitigate for the use or not. I don't know what everybody feels like, but I still feel like I'm kind of stuck on this one, to be honest with you, because they seem to have the right to be able to establish a farm. However, the driveway goes through their property, then it's into the Bennett's property, then back over into the other people's property to connect to the public access. So, I mean, I think that definitely, wasn't what it was intended for. And it's only 12 feet wide at certain points where it is shows on the plan as being 12 feet paved, but the actual areas can be up to 18 feet.
Mm-hmm.
So I don't know what anybody else's thoughts are, but that's where I'm at.
Okay.
Well, I would just say that, sat through 2 hearings. Both sides are represented by attorneys. If there was a case that was squarely on point with regard to this factual situation, I'm sure we would have heard about it by now.
No doubt, I agree. Steve?
So 2 things that I'm dealing with in my mind. So number 1 is, while Easton did right to farm after the covenant, the Dover Amendment was there beforehand. So the right to farm statewide covered by the so-called Dover Amendment is probably there. What's bothering me more than anything else is the Superior Court case. So I'm looking at the complaint. On the bottom of the first page, it says, this is a suit for enforcement of the restrictive covenants, nuisance, intentional infliction of emotional distress, breach of contract. So, and then I believe Attorney Durning said, or Attorney O'Neill said, that the judge found there's a reasonable likelihood of success on the enforcement of the restrictive covenant. So to my way of thinking, maybe, and I'm still haven't made up my mind, the petitioners chose their forum by going to Superior Court, specifically on this issue. Now, I understand town council said, I'm not so sure the preliminary injunction aspect of it is binding on us, and it's not. But I'm thinking that they chose their forum. That's what bothered me at the last hearing. And Attorney O'Neill indicated, well, we have a right to choose where we want to go.
Mhm.
And then when I questioned him, well, why'd you come to the town afterwards? Because the injunction that you got wasn't quite what you were looking for, because it didn't shut them down, in my mind, because that's what they're trying to do, even though they're saying no. They chose their forum, I'm thinking, in the Superior Court, and the same issue was there, and I'm leaning towards allowing the Superior Court to let it play out.
So I'll sort of comment on that. I look at it not as a, they chose the court, so they're prohibited from seeking a zoning violation, more as it's a belt and suspenders. If we find that there's a zoning violation and the Superior Court ultimately rules against the petitioners, they ultimately still prevail. Now, my personal opinion, based upon everything, and this, again, it's got nothing to do with how I'm going to vote on this. It's just, if I decide that we need to incorporate the maintenance agreement, seems to me there's a very clear violation of the terms of the maintenance agreement. Whether or not that amounts to a zoning violation, I'm not there yet. And I'm not sure it does. But, I'm trying to sort of bifurcate the decision, and that's the reason I asked that question in the first place, which is, if we decide, or if we ultimately feel that the maintenance agreement is a private contract between the homeowners, regardless of whether or not we feel it has been violated by the wolves, is there another way for us to find a zoning violation, or do we necessarily need to consider a violation of the maintenance agreement as the zoning violation? And I think we've heard some testimony on that. I'm still not sure, again, myself, how that plays out, but I will say that, that's where I'm struggling with it as well. But I don't fault the petitioners for filing in court first and then coming here. You always have to do one or the other first. And I don't want to sort of impose a belief as to why they came here contrary to what they said they did, or reasons that they said they did. Mike? you're on mute. David.
Yeah, no. Just one of the points that you raised, I kind of wanted to jump in because I think this is a little important, and it didn't come out in the hearing at all. The maintenance agreement was not signed by any board member or town council. So I think the focus should be on the four corners of the special permit. We've heard a lot of conversation about the application, but the application really doesn't have anything to do with it. You should just be looking at the document that they're looking to interpret. The other thing is the maintenance agreement, as John pointed out, it's a requirement. It wasn't a special condition that was imposed on the parties in this case when they went before the planning board. The other thing is it was to be reviewed by town council. In town council's role in reviewing these agreements is that they're not granting each other rights that go beyond what the conditions limited them to, or rights that went beyond what your general and zoning bylaws are. So they were left to negotiate the terms of their agreement, so long as it didn't exceed what the planning board gave them or what rights they had generally through the town bylaw. So I just think it's kind of important to kind of keep that in mind. And that was one of the issues that I thought I wanted to bring up was there wasn't a return date where they went back to the planning board and they said, okay, and they voted on and blessed this agreement. They were just left to negotiate whatever terms that they wanted to and have it reviewed, and then they recorded it.
So,
Thanks, Michael.
so I find myself pretty close to you, Mike Spillane, in how I see the interplay between the court action and our role here. And I'm not. I think it's pretty clear about the distinction between the driveway and the property at 6 Chickadee that there's a difference in. There may be a difference in how it gets analyzed, but one thing I keep coming back to is, and I don't fault anybody for where they went first or anything like that, but I keep coming back in my mind to that there was a preliminary injunction that issued in July, and the request for enforcement was in August. We haven't heard anything that to suggest that the preliminary injunction has been violated. So when the enforcement request is in August and the building inspector looks at it and says there's no violation at that point in time, and that's what we're here to review, is whether there was a whether the building inspector the building inspector found no violation, and so I kind of feel like, well, if the building inspector found no violation after the preliminary injunction issued, then we haven't heard anything to say that there was a violation thereafter. That's how I kind of see the interplay, if that makes any sense.
No, I think I know what you're alluding to, although I don't think our decision necessarily needs to be as it relates to the building inspector's finding in a snapshot on a particular day. I think the overall general use of the property, notwithstanding a preliminary injunction, is what is at issue and what the building inspector was asked to determine. Yes, he did a site visit, and it may not have been an issue that day from his perspective, but I think it goes beyond, that half hour or however long you might have been out at the property, as to whether or not the ongoing and continued use by the Wolves is a violation. And I think that's what we need to decide on today, not necessarily, what the underlying or what was happening that one particular day.
Question for town council, if I might.
Yes.
So, Mike,
Yeah.
what is our standard of review? Is this like NFL instant replay, unless it's clearly wrong, then the decision stands? What is there a standard of review? I was looking for something. I didn't see anything.
No, there really isn't, because under the statutory scheme, under 40A, your zoning enforcement officer, your building inspector, he's a gatekeeper, he's the one that makes a decision. But ultimately, through the appeal process, you are the ones that can override them, because you're going to make the determination whether or not there's a zoning violation in any kind of case. There doesn't have to be a certain level of fault on the building commissioner's part or anything like that. You're basically just sitting in his stead at this point. Again,
Okay, thanks.
you probably are all aware of this. It would have to be a four out of 5 vote to over. So.
Ready to vote?
I don't know, are we?
I think that before we start voting on anything, we need to carefully craft the question of the resolution that we're gonna vote on. Because
You're either gonna find that there is a zoning violation or there isn't. It's not, this isn't a detailed, why they found a zoning, and Mike, correct me if I'm wrong. I mean, it's just, we don't necessarily have to determine that there was a violation in A, B, C, or D manner. It's, do we think that there was a zoning violation? In which case, then we would vote to determine that the building inspector's determination was incorrect.
Yeah, so your motion would be, your motion would be whether to overturn or uphold.
John, I don't think we have to go into detail as to the reasonings for the decision.
Yes, I think you're right. I guess a follow-up question is, do we vote on each special permit separately? Or are we gonna do this, combine them into one?
I don't think it's a decision on the special permit. It's a decision, or it's our determination as to whether or not the Wolf's operation of the farm on their property violates a zoning bylaw or improperly being used in town under the circumstances. And it could be that you decide that there is a zoning violation because you think they violated the maintenance agreement, or you think the special permit has been violated because they didn't come back and ask for a change of use. Or you may determine each individually that what they're doing is in compliance with the right to farm bylaw, and they are, if they are violating, the maintenance agreement, it's outside of our purview. So I think you can find, your answer either way without necessarily having a long, sort of drawn out, detailed motion.
Okay, I mean, and I only asked that question because the initial zoning enforcement request was for a violation of the 2 special permits.
Mm-hmm.
So, I mean, if we're ruling, acting sort of in an appellate capacity for what the building inspector did, the building inspector was asked to see if there's a zoning violation vis-a-vis those 2 special permits. So I think that's what we should be deciding.
Michael, do you feel that's incorrect in that analysis, or is John on point there?
Well, I was just digging through everything. A lot of paperwork in this one.
No, so his point was that the appeal was of the building inspector's decision as it relates to the 2 special permits, and should our decision be based solely upon what the applicants filed the initial appeal on, or are we able to look at the totality of the circumstances?
I was looking for the request for the zoning enforcement, and it's kind of, they don't really specify it on the application, but the memo mentions both the special permits. But I also looked up the letter from Kevin Greiner. He just said he investigated the property and he found no evidence of any zoning violations. So I think the vote would just be based on that, whether or not you uphold or overturn his determination that there's no zoning violations. 'Cause he kind of just, there's a very brief letter from Kevin. It was only three sentences long.
So to sort of address John's concern, and I completely understand where he's going from, we're not limited. This is not, you know, a court decision in an appeals court where we're limited to the information that the court had in front of it at the time or what it was asked to do. We've you know, spent a few hours now gathering information from all sides and the parties. We can look at this from a totality of the circumstances and make our own decision whether or not a zoning violation has or has not occurred. So,
yeah, and following the meeting and following the vote, either way, whichever way it goes, I will put together a decision for you to review and sign. Touch with Suzanne, and we'll get something to you for your next meeting. So you can vote tonight. I can put something together, and maybe at your next meeting you can take a look at it, and you know, you don't have any changes, you can sign it, which is what I usually do in these cases.
okay.
I guess I was asking the question because I'm looking down the road here and I think we should try to avoid any ambiguity in terms of what we're evaluating and what we're deciding.
Okay. Well, like Mike said, I mean, he'll put together a decision based upon our basic reasonings, but you know, for purposes of do we go forward or do we determine that there was a zoning violation or not, I think it's a relatively simple motion to either uphold the initial decision or override it, overrule it.
And does that also include the use of the property as a farm?
That question was never raised in the request for enforcement, and also, and I think tonight, fortunately, they made it clear, because the first meeting that we had, it was kind of vague what they were seeking relief from, but I think tonight they made it very clear. It was just about the driveway, about the driveway, about the driveway. They've never really challenged the underlying use. And actually, Stephen had a great question about whether or not the wolves, this would even be an issue if the wolves had separate access to their property. And I would suspect that Mike probably would have said yes if there was separate access.
Okay. All right. I'm sorry. I'll stop asking questions.
No. They're all good questions, John. No problem. Mike, can if I just clarify one other question that I have, and Steve raised this at the beginning of deliberations. The Dover Amendment was in effect when, and I think the problem or the issue, let me backtrack, that if the wolves had their own separate access and driveway to their property, would the use of their property even be questioned at this point? And probably not in my guess, but you know, there wouldn't be a driveway maintenance agreement that, you know, has allegedly been violated. So that probably precludes much of the issue. That being said, Steve raised a good point that, you know, we didn't really address, and that is the Dover Amendment pre-existed the granting of the special permit, which does specifically make reference to residential use. Understanding that the bylaw, the right to farm bylaw, was not yet adopted and was later adopted and intended to apply to, you know, all property. Is there an argument to be made? Is there a reason to suggest that the special permit overrode the Dover Amendment and precluded this particular property from the benefits of the Dover Amendment?
Well, there was no, if you look at the special permit, there were a couple of findings about the current use at the time where, all three lots were going to be used as residential, but you don't have a specific condition in the special permit that says that We're agreeing to the creation of this lot for residential purposes only. In the bigger issue there actually is the Wolf's lot doesn't even have the condition whatsoever because the special permit pertained to the newly created lot that the Wolves had cut off from their property.
Okay, thanks, Mike.
Yeah, that's the crux of the issue for me is, because I see restrictions all the time. And, in this town and other towns continue to change zoning, and you have people that, were living next to what they thought were residential suddenly becomes high density and they can't really stop it. But so, I think they're in violation of overburdening that easement, I guess. But, if they came in to ask for permission to use it for that, I don't see where we could say you can't farm there. I think the right to farm is pretty clear. It's just, and I don't know if the maintenance agreement is what we should be, it says residential in that many times, but, what's the definition of just residential? No trucks. People get deliveries and different things, but, so I don't know if somebody wants to make a motion or not, but.
Just to go to Tim's point, I'm not trying to sway anybody in any direction because obviously I'm not a voting member and it's not my role. I just, at the end of the day, it's the maintenance agreement is a privately entered contract where they said, you know what, we're going to set the parameters for the use of this driveway. And they had the ability to do that, and they did, as long as they didn't, like I said, exceed any of the conditions of the special permit. And it just appears to me that they are before you tonight for you to kind of make a determination over their contractual rights that they established when they signed this contract. And I think Stephen pointed this out in the first meeting. That's a role for the Superior Court, if you ask me, or the Land Court. You can't really, interpret a contract and say, hey, listen, this is what your rights under the contract are, and this is what your rights under the contract are. So I think you kind of put in a tough spot with this petition. So
I make a motion, Mr. Chairman?
Yes, nobody jumped in, so.
Yeah, okay. So I move that we uphold the building inspector.
Okay. Does anybody want to second that motion?
I'll second it.
Jeremy seconded it. All those in favor? Steve?
Yes.
Jeremy?
Yes.
John?
Yes.
Tim?
No.
I'm also not going to vote in favor of Steve's motion. However, that does mean that by a vote of 3-2, the decision of the building inspector is upheld by the board. We would have needed 4 votes to overturn his decision. Correct, Michael?
yes, yep.
Thank you, everyone who appeared at this hearing. Just know it was not an easy decision, I don't believe, for any of us. And I wish all parties the best moving forward. So, Mike, you'll get us a decision to review and proceed accordingly on that?
So we'll get something together for you guys.
Okay.
Well, hey, thank you very much. You guys have a good night.
Thank you. You too, Michael.
Thank you.
Thanks.
All right. Take care. Steve, do you want to revisit the meeting minutes from the
Yeah, the
last
minutes,
meeting?
yeah. Yes, I make a motion to approve. I had a chance to look at them while
Okay.
we were having the meeting, just to double check them, so.
With the changes, I second
Yeah.
with the changes that Mr. Curran had
Yeah,
previously mentioned.
the edit that John had.
Right, with Ryan Lumpkin.
Indicating
Yes.
Mr. Cook was not present at the meeting, although you were in spirit. Okay, so all those in favor, Steve? Motion made
Yes.
by Mr. Merlin, seconded by Mr. McCall with the edit requested by Mr. Curran. All those in favor, Steve?
Yes,
Tim? you're on mute. Tim.
Yes.
Okay, thanks. John,
Yes.
Jeremy,
Yes.
and I vote to approve as well. Anything else? Anybody want to bring up?
I just comment that, oh, am I on? Oh, no, I'm not on mute. Just
Nope,
comment, I think you all did a fantastic job on this. It's not an easy decision. And there were a lot of elements. I'm bummed that I missed the first one. I had another obligation that I couldn't get out of. So definitely not an easy decision. I think you all did a outstanding job of really delving into it, regardless of whether I think the outcome was correct or incorrect. That's why we have a board and we vote on things. So just congratulations on a lot of hard work and doing the town's business.
Thanks, Ryan. Appreciate
Thanks,
that.
Ryan.
And I'll echo Ryan because this was not an easy one. Everybody was prepared. Everybody had good questions, and it took a lot of time, and there were a lot of information presented, which obviously everyone dissected and did a good job with. And I had a feeling we were going to come out somewhere in that 3-2 range somewhere, one way or the other. So
I
it
have
is
a
what it
question.
is.
I have a question when it comes onto this, because obviously this becomes something that could come up again in the future, right? Obviously, you got to have the right type of land and stuff like that. How does a decision like this lead to potential updates to the zoning bylaws for better clarification in the future? Or is this just a matter of it's a case-by-case basis?
So there's never a precedence on any decision that the zoning board makes under any set of circumstances.
I agree.
Right? So, this more or less the same exact scenario could come before us in 3 years with 2 different property owners, and we could find completely different. I mean, the makeup of the board could be different. So there's no look back period where, now it may be persuasive to the members of the board, but at that time, there's nothing that says this decision carries forward to, a future decision as it relates to whether or not the bylaw itself needs to be clarified. That may be a possibility, but,
Well, yeah, I mean, the bylaw isn't limited to, when it comes to common driveways, it's not limited to, it doesn't say it only pertains to residential properties. So, I'm not sure that when they put it together, they ever envisioned a scenario like this.
Right. No, I agree. It we'll see. How's that? I don't know. I don't
didn't
know
know
what the
anything
right
about
answer is,
right
but
to
it's a
farm
good point,
before,
Ryan.
so yeah,
What's that?
I learned a lot. I didn't know anything what that meant before. Now I know a lot more about it. So it's definitely interesting how it's applied. So
Yeah.
I mean, yeah, in theory, everybody in town can start running a farm on their property.
I mean, you need the acreage, obviously, and so forth, but there's, maybe.
Maybe. That is the correct answer.
There is a maybe in
All right.
That's what keeps all you attorneys employed.
That's it.
True.
Anyhow.
Motion to adjourn in order?
Yes, I believe so. Motion made by Mr. Merlin to adjourn, seconded by
Seconded.
Mr. Curran. All those in favor, Steve,
Yes.
John,
Yes.
Tim,
Yes.
Ryan,
Yes.
and I'll vote to adjourn as well. Thank you guys very much. We do have 2 hearings simultaneous on the same piece of property right now that are coming in for December
13th.
Thank you, Suzanne.
Okey-doke.
An administrative appeal and a variance on 142 Lincoln Street.
Right.
So, I don't think it's going to be as hotly contested an administrative appeal, however.
Probably not.
So anyways, we'll see you guys in about a month, little less than a month, and otherwise have a fantastic Thanksgiving, and we'll see you then.
All right.
Okay.
Take it
You
easy.
too. Bye.
Thank you.
Everyone have a great time.
Good night, everyone. Thanks.
Good night.
Bye.